The offences before you are available, and we humbly submit that you exercise your discretion in favor of the accused person in the dock, admit him to bond in bail, and allow him to appear and defend this matter when he is also taking care of his family. We humbly submit.
The first accused has been directed to provide the medical documents. I have a copy. He was referred a 3-day rest. He was also referred to Aga Khan of India. When he went to Aga Khan, he said they didn't have the facilities, so he would have to travel to India for the treatment. He was hoping to travel on Sunday. For approximately 21 days. You can see from the air ticket is meant to. Oh, sorry. From the air ticket, you can see is meant to return on 9th November. That is why he was seeking for 30 days to defer his plea taking.
The date of travel is on Sunday. Also, the unit is set to come up on the 9th of November. The time slot for 30 days, I still regret you, it's too long. Since according to the medical documents provided, his diagnosis is unknown. I was seeking for mention to confirm the medical documents. That is maybe a week after, next week. And then after the court can give us directions on the date for plea taking.
I have a few rebuttals, just one. I would say that the time taken is not too long, 30 days is not too long, because if he comes back on 9, we'd expect him to at least have a week rest, given the condition. I would still pray for 30 days. On 17th.
On Monday?
Yes, that's okay.
Yesterday there was another council here.
Yes, I'm holding his brief.
He told this court passionately that the accused was a fit for condition admitted at the Khan hospital and was preparing to travel yesterday.
I think from from the letter, when he was in Aga Khan. Oh, yeah, but I think they realized that they don't have the facilities to treat him, so that's why he opted for India, yeah.
And the travel itinerary for yesterday?
Probably he probably did not book for yesterday because now he had to travel outside, yeah.
Then I don't know whether it will be asking too much to accommodate me in the afternoon with the other Rudy.
Yes, afternoon.
You already have the Sunday.
Apart from the one you have confirmed. Okay. Just a moment.
Good.
On the next mentioned date, in view of the submissions made by the advocate for the first accused person, plea taking for the first accused person is deferred to 17th of November this year. Counsel for the first accused to inform his client of the date, and the investigating officer to also serve the first accused person with summons requiring his attendance before this court for plea taking on that date. With regard to bail bond issue for the second accused person, I have taken note of the submissions made by counsel of record. I have also perused the affidavit sworn by Corporal Dennis Mugambi on 24th of October 2025, filed hearing. From that affidavit, there is an indication, paragraphs 4 and 5, that the second accused has been out on police bail since the time of arrest in August 2023. It is upon that paragraph 5 of the said affidavit that the accused persons have been reporting to the investigating officer for extension of police bail since then. The said affidavit, in my view, confirms that there is no risk of absconding on the part of the second accused. While it is upon that paragraph 7 of the said affidavit that the accused person's places of abode are unknown, details of the second accused person's place of abode given in submissions by defense counsel for the second accused person. There is an averment at paragraph 6 that the complainant informed the investigating officer that the accused persons threatened him with a pistol on 26th of August 2025. The investigating officer has stated on oath that that alleged threat was not reported, and he was not shown any occurrence book where the said threat was reported. That alleged threat is a serious one. However, it has not been substantiated, hence remains a mere allegation. The authority of Jeffa versus Republic, reported in 1973 volume of East African Law Reports at page 39, is clear that the court should not rely on unsubstantiated allegation as a basis for denial of bail bond pending trial. The principal consideration in every application for bail bond is whether an accused person, if released, is likely to turn up for trial. The material before the court indicates that the second accused person was granted police bond and complied. I therefore, for these reasons, find no established compelling reason why the second accused should not be granted bail or bond. I have taken note of the fact that the second accused person was out on police bail of Kenya shillings 100,000. He is alleged in the particulars of offense to have obtained about Kenya shillings 35 million by false pretense. He enjoys presumption of innocence under Article 50 of Article 2A of the Constitution. However, bond terms are required to be reasonable as provided at Section 125 of the Criminal Procedure Code and Article 49 of Article 1H of the Constitution. For these reasons, the second accused person is granted bond of Kenya shillings 2 million with with one surety of the same amount. The case we mentioned for pre-trial on 7th of November 2025, as already stated, the first accused shall take plea on 17th of November 2025. A report on verification of medical documents and air tickets relating to the first accused person to be presented on the next mentioned date of 7th of November 2025.